I'd like to welcome you to our first educational forum hosted by the Massachusetts Gaming Commission. I'm Gail Cameron, one of the 5 new appointed gaming commissioners. I'm a former Lieutenant Colonel, Deputy Superintendent with the New Jersey State Police with some casino gaming oversight. My fellow commissioners, who are all here today, have diverse backgrounds, tremendous amount of experience, and we share the same commitment to developing a secure and robust gaming industry here in the Commonwealth. We are a full-time commission with responsibilities, just to name a few. We are responsible for determining which applicants will be awarded gaming licenses, writing regulations, conducting background investigations, working with our law enforcement partners on policing matters, regulatory matters. To assist us with our startup operation, we are just completing our 5th week, by the way, as a commission. We have invited subject matter experts from other jurisdictions to help educate us on the best practices in the industry, lessons learned. We are very fortunate to have a distinguished group, an experienced group of panelists and speakers here today. This training was designed to assist us, the Commission, as well as our other partners who have gaming oversight in learning the best practices in the industry. But we decided it was important enough and there's enough interest in casino gaming to open it to the public so that all may benefit from this day of education. We realize that there are many important subjects concerning and surrounding casino gaming, but we set this program today to really address the startup operation. What do we need to know immediately to make good decisions and move forward? We will have other forums, other topics will be discussed. Today's panelists will, and I think you should all have a program, you got one on the way in, if not, they're on the table outside. We're going to talk about things like determining priorities, lessons learned, as I just mentioned, nuts and bolts of financial oversight, writing regulations, setting up an office. And the end of the day, we're going to end with our law enforcement panel talking about those shared responsibilities in enforcing gaming. We will not be taking live questions today. We have a jam-packed program, but we do have a Twitter account, and you can text questions in. We'll bring those questions to the moderator. The moderator will, decide how much time we have to answer some of those questions. So please don't be disappointed if we don't get to all of them. I'm going to give you the hashtag now. It's the pound sign at AskMassGaming. Say that 3 times fast. Again, the hashtag pound at AskMassGaming. All one word. Just a few other housekeeping items. We'll take a 15-minute break between the first and second panel. We will take an hour at lunch today. We'll try to hold that to an hour if we can. We'll let you know exactly how much time when we take the break. The food court is open here at the Convention Center, so if you choose not to leave the premise, you do not have to. Out in the hall, make a left, there's a food court. Let's see. Okay, now I want to move on with the program. We are very fortunate to have the president of the American Gaming Association join us here today, so it's my pleasure to introduce President Fahrenkopf. The organization addresses regulatory, political, and educational issues affecting the industry. He has a distinguished career, 17 years experience as a trial and gaming attorney in Las Vegas, and he's here to talk to us about the state of the industry today. So, thank you, Mr. Fahrenkopf.
Thank you, Gail, and good morning, everyone. It's a particular treat for me to come back to Boston. I've spent a heck of a lot of time here. One of my daughters is a graduate of Boston University Law School. My youngest daughter did her residency and spent 5 years on the faculty and chief attending physician at Boston Children's Hospital. And then, of course, my dear, dear friend, Paul Kirk, former Senator Paul Kirk of Massachusetts, and I, as co-chairman of the Commission on Presidential Debates, brought the first presidential debate to UMass Boston back in 2000. So I always enjoy coming to this great city. Let me first indicate to you, and I hope you'll excuse me, I'm not very good at this, but we're going to try to keep this thing moving and in sync with what I'm saying. But first of all, I represent the commercial casino industry. And I emphasize the word commercial in that we do not represent Native American casinos. And as if you study this at all, you'll find that there are more Native American casinos in more jurisdictions than there are commercial casinos as it is spread across the country. And we represent them at the federal level. We do not lobby or get involved at the state level, although over the past 17 years, on many occasions, I've testified before legislative committees in various states that are considering whether or not to expand gaming. But we do that only upon request, and so we're not really involved at the state level. Let me start to the commissioners down here in front by saying thank you. Thank you in advance for the important and very, very critical commitment that you're making to the state of Massachusetts. As you're going to see from the folks that you have here, experienced people who have been in the regulatory regime for many, many years across the country, it's a tough job. But you're in a wonderful position because you've got experts here who have been regulators who I think are going to be able to give you a tremendous amount of background. We were created, as this says, in 1995, and I'm the only president and CEO that we've had. There was no representation prior to that time, and so it's been a real treat for me over the last years. But let me talk about the way it used to be for just a minute. I grew up in Reno, Nevada, and I can tell you, gaming in those days, and this sounds unpolitically correct, but it was the way it was, is that casinos, back when I was a kid, provided table games at which men gambled, and there were a few slot machines around the back of the casino for the wives to play while the men were gambling. Now that is very unpolitically correct today, but it's really the way it was. But the world has changed dramatically, particularly as slot machines have spread in popularity. But much of the change since when I was a kid in Reno is due to the rigorous regulation and appropriate law enforcement oversight of our industry. We're an unusual industry. We want regulation. We want tough regulation because it provides the integrity to our business. Most industries, as you know, don't want to be regulated. This is an industry that needs regulation and wants regulation. One of the most important shifts was made a number of years ago in ownership from private companies to publicly held companies, and the accompanying resources that led to the creation of the fabulous resorts that you've seen around the world and which are the hallmark of the industry today. The industry has also truly become global during the past 2 decades. As I told some of the commissioners this morning, I'm leaving in about a week to go to Macau, where that the Asian market has grown so big that we do a Global Gaming Expo Asia in Macau every spring. So it is a global business that's happened today. And the patrons of casinos have also changed dramatically. In today's casinos, men and women from all walks of life and from across the nation and around the world not only play slots and cards, but in the new mega resort era, they enjoy fine dining, Michelin star restaurants, shop at a variety of stores, and experience world-class entertainment shows. The typical casino patron has a higher than average annual income and is either a college graduate or has some college education. And they no longer have to go to Nevada or New Jersey to visit a casino, because chances are with commercial or tribal casinos now in 38 states and soon to be 40 with Ohio and this state, there's a casino within easy driving distance wherever you are in the United States. Of course, not all of those casinos are the mega resorts, but even in the smaller non-resort casinos, they offer sophisticated, exciting games, and they focus on providing patrons with great entertainment experience. I want to tell you a little bit more about the industry I represent. Today, there are 566 commercial casinos in 22 states that generate just under $50 billion in consumer spending and 400,000 direct jobs in 2010. And in addition, when indirect and induced impacts are taken into account for you economists here, the industry supports an estimated additional $76 billion in spending with suppliers and other businesses, and more than 470,000 additional jobs with salaries and benefits, totaling almost $25 billion. Taken all together, the commercial casino industry supported about $125 billion in spending and 875,000 jobs in the U.S. in 2010. The economic activity was roughly equivalent, we were quite amazed by this statistic, 1% of the $14.5 trillion U.S. gross domestic product in 2010. And I believe we sent to the commissioners a copy of the Brattle Group's study from which most of these numbers are derived. That study also compares the gaming industry with others that are similar in size and scope. And when compared with industries of similar revenue, we generate far more jobs, and the average salary and benefits provided our employees in our industry totaled almost $42,000 a year, more than many segments of the broader recreation and retail industries in the country. And then there are the tax benefits to the states and communities where commercial casinos operate. Nearly 3/4, or 71%, of our community leader poll, which I'm going to get into a little bit more detail in just a moment, those poll respondents say casinos generated a net tax increase, and well more than half, 57%, say casino tax revenues allowed their communities to avoid cutting key programs, and we were able to start new projects that they would not have otherwise been able to do. Now, that response is understandable when you consider that in 2010, the commercial casino industry directly paid almost $16 billion in taxes, and that another $9 billion can be indirectly attributed to our companies. The AGA companies that operate casinos, large and small, are also committed to being good corporate citizens, and even the smallest casinos adhere to a formal code of responsible gaming conduct and supports internal and external efforts to address problem gambling. So as you can see, casino gambling has become a critical component of the U.S. and global entertainment economies. Our casinos and the manufacturers, suppliers, and vendors that support our business are creating jobs in almost every state in the Union, and our employees and local operators have become a part of the fabric of the communities where they live. Now, as the industry has evolved and grown during the past few decades, so too has the technology that drives our operations. For example, many games are now networked and designed to accommodate multiple players or allow for a single machine to host a variety of games. Technological changes present a host of new challenges to regulators. However, technology also offers regulators the tools to even more closely monitor the games, casino management, and financial activities. And in addition to the technological changes, today's commercial casinos are also subject to more sophisticated federal regulation from the IRS, the SEC, the Treasury Department, and believe it or not, we spend a lot of time with the Coast Guard in our office, riverboats. All of these factors, domestic and global geographic expansion of gaming, the modernization and diversification of casinos, technological advances, and greater federal oversight contribute to a growing interest in modernizing, streamlining, and coordinating current gaming regulations, which makes this meeting extremely timely. Several gambling states have already begun review of their regulations. In Nevada, Governor Brian Sandoval recently convened the Gaming Policy Committee to examine current regulatory technology and to work towards modernizing regulation of the industry. Similar conversations are taking place in other jurisdictions, including Missouri, Mississippi, and Iowa. As a major stakeholders in these discussions, the AGA and our member companies look forward to working with regulators as they undertake these reviews, or, as in the case here in Massachusetts, you develop your own set of regulations. Last fall, the AGA organized a task force of compliance officers, lawyers, and other industry experts, including former and current regulators, to identify necessary regulatory reforms and to determine practical opportunities for change. The result was a white paper, which we think we sent to you, entitled Improving Gaming Regulations, 10 Recommendations for Streamlining Processes While Maintaining Integrity. The paper, as its title suggests, recommends broad-based regulatory reforms and state-specific actions, such as improving the licensing process, simplifying the gaming licensee's ability to gain access to financing, reforming regulation of gaming machines, and reporting requirements. Let me tell you about just two simple, and these are very simple examples, of ways new technology could make current regulations more efficient and effective. First, many jurisdictions require that an employee's fingerprints must be taken by a law enforcement agency within the jurisdiction as part of the licensing process. Many employees are licensed in multiple jurisdictions and subject to continuing license renewal. If you talk to anyone in the manufacturing business, if you talk to people at IGT, or you talk to people at Bally, some of their officials are licensed in over 100 jurisdictions around the world. And they have to go to all of those places to have their fingerprints taken every year. You know, it's just not necessary. With today's technology, regulators could accept electronic images of an applicant's fingerprints from a legitimate law enforcement agency rather than that time-consuming task of visiting an agency in person whenever and wherever fingerprints are needed. Similarly, video conferencing could be used for conducting regulatory licensing interviews. In the current system, applicants often have to travel long distances, even abroad, for a relatively brief 10-minute interview. We could all save time and money by taking advantage of a reliable technology, video conferences, the use of Skype, whatever you want to do, which most businesses use in today's modern world of economics. So these are just simple suggestions. And then we get in the paper to others, so I hope they will be helpful to you. But these examples I indicate to you, and I believe very clearly, demonstrate the need not for less regulation. Let me make clear, I'm not saying we need less regulation, we need more efficient regulation. And as the white paper points out, duplicative or dated regulations increase costs and divert industry resources away from investment and innovations that create jobs and economic opportunity. They sap the creative spirit of employees and waste taxpayer dollars and industry resources on misguided enforcement. And they reduce the morale of regulators who recognize they are imposing standards that are losing their relevance. Massachusetts, I submit to you, is in a unique and enviable position because you, new regulators, have the opportunity to craft regulations that can address modern gaming from the beginning. You can start fresh and incorporate most of the changes your peers nationwide have implemented and are discussing. And as you undertake the task in creating your regulations, I hope you'll consider our paper. And you really, today, you know, Nevada went with gaming in 1931, then took New Jersey to go online in, 78. So New Jersey faced very much what Massachusetts regulators face. What do you do? Where do you go? Who do you get the assistance from? And you also have here, in addition to the New Jersey mob, the New Jersey group that's here, you have Pennsylvania. Pennsylvania is a large jurisdiction that just started. And the Pennsylvania regulators who are here and going to share their thoughts with you have just gone through what you're going to be going through here. So you have a remarkable opportunity here to gain from what's already gone before. Now let me talk about a couple of things that I think all regulators must consider, particularly when developing regulations. As you can imagine, I've closely followed the media as you've debated here in Massachusetts whether or not to have casinos, and I've heard the litany of anti-gaming claims, and it's understandable, and you should have concerns about the widely claimed negative social impact of commercial casinos. In the last 17 years, I've been in almost every state speaking about this, whether before a legislative committee or organization that's brought in. The claims are out there. There are people who are professional opponents of gaming. We poll every year. We have for 20 years, and as you'll see in a moment, because I'm going to refer to one of these polls, we use Peter Hart, pollster for the Wall Street Journal and NBC, and pretty much over the last 20 years, it's been pretty consistent. 85% of the American people have no problem with gaming for themselves and others. But there is a hardcore 15% that are opposed to all forms of gaming. And most of them, it's because of their religious faith, and you have to respect that. But nothing's going to change their mind. But they're going to be there. And I think it's important that you, as regulators, hear both sides. You should hear from advocates, you should hear from opponents. But I would just tell you, as I've told most, follow the rule and suggestion of my old boss, Ronald Reagan, who, if you go back to the 80s when we were in the Cold War with Russia, remember what he said: trust but verify. Trust but verify. Listen to both sides, but then verify. You don't have to really trust any side. You have the advantage with people who are here today and will be open to you. But if there are questions, go back and talk to the mayors. Go back and talk to the chiefs of police. Go back and talk to people in jurisdictions that have just brought on gaming and find out what the truth is. Trust but verify. Now, I mentioned a minute ago, MGC Wall Street Journal pollster Peter Hart. He recently conducted a poll that went to elected officials and community leaders in casino jurisdictions. We didn't go to Nevada and we didn't go to New Jersey because those states have had it for a long time. We went to emerging jurisdictions. And you'll see that 83% of elected officials and community leaders in these jurisdictions say that the introduction of casinos has met or exceeded their expectations. That same overwhelming majority says that the overall impact of casinos has been positive. These civic leaders view casinos as vital community partners. The positive feelings toward us don't stop there. More than 8 out of 10 community leaders think that casinos have done a good or fair job of producing promised benefits, such as taxes and government revenue, quality jobs, increased local and regional economic activity, and increased tourism and expanded entertainment options. 76% of them say casinos have done more to help than hurt other area businesses, because that's an argument that you will hear. And meanwhile, nearly 3/4 say casinos are good corporate citizens. But perhaps the most telling result is that when everything is taken into account, 76% of these community leaders would choose to vote yes if given the chance to go back and cast the deciding vote whether to allow casinos into their communities. And community leaders aren't alone. You know, I thought one of the interesting experiments was Iowa. When Iowa in the late 80s brought in casinos, they did something very interesting. They said it was county option, and I think originally it was 11 counties that opted to have casinos. But every 8 years, they would get to go to the polls, the people in those counties, and vote whether to keep them or not. After 8 years, the first election, 70% said keep. Then another 8 years, 75% average said keep. It got to be so high it was no longer an issue. The Iowa legislature did away with the 8 years. So, and I'm talking about people in Iowa. I'm not talking about people from Nevada or New Jersey where they've lived with it for, you know, many, many, many years. Another area of natural concern are those who cannot gamble responsibly. I know that responsible gaming is a priority for you, and it's also a priority for the gaming industry. We take this issue very seriously and work hard to make sure policies and regulations, I guess I got to go another slide here. While gaming opponents would have you believe that pathological gambling is a rampant problem that tears communities apart, the truth of the matter is that countless peer-reviewed research have confirmed the prevalence rate of pathological gambling has held steady at approximately 1% of the adult population for the past 35+ years. If more casinos in and of themselves were going to create more gambling problems, then the explosive growth of casino jurisdictions over the last 2 decades would have seen a proportionate increase in the prevalence rate of pathological gambling. Research shows that is simply not the case. Now, that is not to say that we should spend the time that's so necessary to help those who can't gamble responsibly, because that 1% have real problems. It's problems for themselves and their families and those around them. And our companies make every effort to address this important issue. In fact, the issue of responsible gaming was on the agenda. I brought it up 17.5 years ago at the first meeting when I took this job, and that we had to do something, and we had to face it head on. And I think we've made significant progress on this topic, and I want to take just a few moments to talk about 2 specific programs. The first is the AGA Code of Conduct for Responsible Gaming, which was created in 2003 to establish a consistent industry-wide approach to responsible gaming across all our member companies. The code is a pledge to employees, patrons, and the public to promote responsible gaming in every aspect of the casino business, including employee training, customer education, the prevention of underage gambling, responsible alcohol service, and responsible marketing and advertising. The code also details the commitment of AGA members to continue support for research initiatives and public awareness activities surrounding responsible gaming and underage gambling. Specific provisions include a commitment to train employees with regard to responsible gaming and responsible alcohol service, as well as a provision to allow patrons who have a gambling problem to self-exclude themselves from gaming activities. And this self-exclusion also includes opportunities for patrons to request to be removed from promotional mailing lists or to revoke privileges for casino services, player club privilege, on-site checking, etc. All our companies are committed to the provisions of this code. And it has become a model for responsible gaming programs, not only here in the United States, but in international jurisdictions. And many non-member AGA casinos, non-member casinos, not members of AGA, across the country follow it as well. But it is just one part of our industry's commitment to responsible gaming. In 1996, the AGA founded the National Center for Responsible Gaming, the NCRG, which is the largest private funder of research on gambling and addiction in the nation, and the only national organization exclusively devoted to funding research that helps increase understanding of pathological and youth gaming. The organization is devoted to finding an effective method of treatment for the disorder. Its mission is to help individuals and families affected by gambling disorders by supporting the finest peer-reviewed research, encouraging the application of new findings to help improve prevention, intervention, and treatment strategies, and to advance public education about gambling disorders and responsible gaming. The NCRG's competitive grant-making process is overseen by a scientific advisory board that is composed of leading independent scientists with expertise in addiction and related topics. They monitor the conduct of the research grants, and peer review panels evaluate all proposals based on criteria used by those at the National Institutes of Health. As the AGA's affiliated charity, the NCRG the AGA has provided some $22 million for research and education programs that have stood the test of time and been reinforced by numerous studies conducted by both gaming proponents and gaming opponents. I should note that one of the foremost researchers on gambling and addiction is right here in your own backyard. Dr. Howard Schaefer and his team at the Division on Addictions at the Cambridge Health Alliance have probably contributed more to this field of research than perhaps anyone. And the NCRG has been proud to support their work and benefit from their expertise over the years. Given the NCRG's high standards for awarding grants, NCRG-funded studies have resulted in the publications of more than 170 articles in highly competitive, peer-reviewed scientific journals, such as the Harvard Review of Psychiatry, Addiction, Psychology of Addicted Behaviors, the American Journal of Public Health, and the Archives of General Psychiatry. This peer-reviewed research has been conducted at some of the most prestigious institutions in the U.S., including Harvard, Yale, Johns Hopkins, Massachusetts General, the University of Minnesota, Duke, the University of Iowa, the University of Michigan, and leading educational institutions around the world. The NCRG is committed to translating this research into practical applications that prevent problem gambling. Now, many of these applications will be of use to you as your state prepares to open commercial casinos. In fact, the NCRG has already begun building a relationship with stakeholders in Massachusetts. Each year, the NCRG Road Tour travels to a new city to share information about the latest research on gambling disorders and make key stakeholders aware of the science-based programs and resources the organization has to offer. In fact, my team just returned from Miami. Chris is here from the NCRG, and they were in Miami on this year's road tour. Last year, the road tour stopped in Boston and partnered with the Massachusetts Council on Compulsive Gaming for several events. The NCRG maintains a strong relationship with that council today. So as your state moves forward with gaming, both the AGA and the NCRG can serve as excellent resources when addressing the issues of responsible gaming. Casino companies in Massachusetts can adopt the Code of Conduct. And of course, if any of the AGA members are eventually licensed, they're already bound to the code. You also should be aware of the Harvard-developed eMERGE training program. It's also a tool that could prove helpful here in Massachusetts. eMERGE stands for Executive Management and Employee Responsible Gaming Education, and it's the only program of its kind grounded in scientific research that has been translated into an acceptable training tool for gaming employees across the board. Additionally, the AGA has a variety of tools to educate consumer customers about how slot machines work, what the odds of each game are, and ways to play responsibly. Research has shown that understanding the odds and how casino games work are key elements of making responsible decisions when playing. Such an understanding also helps prevent gambling problems before they start. The NCRG also provides resources that can be used to address underage gaming, one of which is collegegambling.org, a first-of-its-kind online resource designed to help colleges and universities address gambling and gambling-related harm on campus. The website was created for campus officials, students, and parents, and it brings together the latest research and best practices in responsible gaming and in the field of addiction awareness and prevention. Massachusetts professors from Boston University School of Public Health, Bridgewater State College, and the Harvard-Cambridge Health Alliance were among the blue ribbon group that helped in the development and utilization of this tool. The industry has a strong relationship with the NCAA, and we have over the years worked together with them to prevent youth gaming and to monitor sports betting patterns for sure, to identify and prevent potential cheating or point shaving. The NCRG will be present at the NCAA's annual gambling summit later this fall to share the college gaming resource and further strengthen that partnership. The NCRG's effort to prevent youth gambling also included a science-based guide for parents called Talking with Children About Gambling. It helps parents and others who work with kids to deter children from gambling and recognize possible warning signs of problem gambling and other risky behaviors. Several educational opportunities are also available through the NCRG, including its annual conference, which is, I believe, the leading gambling and addiction conference in the world. People come from all over the world, clinicians, professors, people who are really involved in trying to solve this problem. In fact, Rachel's here. Rachel Volberg has been at that conference a number of times. The NCRG also hosts a series of workshops and webinars for counselors and clinicians across the country. It also offers an extensive library of publications to help everyone, from business leaders to the general public, have a better understanding of gambling disorders and responsible gaming. Now, I know my office, as I said, sent out packets to each of you, the members of the commission, and I hope you'll take the time to look those over, and we'll find them informative. These tools are already in use in gaming jurisdictions across the country and around the world and can be tailored to the individual needs of each state. I also encourage you to go on our website and the NCRG's. The websites are located here on the screen. I think both of these sites offer a wealth of resources, including many I've discussed today. Also of note, our annual State of the States report will be released next week. It includes much of the public opinion polling data I've just shared with you, as well as detailed national and state-level economic impact data on the commercial casino industry for 2011. And it goes state by state, giving you the revenues, the jobs, et cetera. Probably more information than you'll ever want to know. We'll be sure to send a copy to all of you after it's released publicly next Wednesday. Let me close by reiterating my commitment and that of the AGA member companies in working with you and other regulators to improve on what already has been for decades a regulatory success story. The proof of its success is the trust our patrons have when they come to our casinos, and the reward for both you as regulators and our companies is in the hundreds of thousands of jobs, millions, billions of dollars in economic stimulation and tax revenue. We're an industry that welcomes the role, as I've said, of the men and women in this room who will be regulators. So I want to conclude by a sincere thank you for inviting me, and remember, when all else fails, trust but verify. Thank you very much.
Thank you, President Fahrenkopf. Very informative presentation. May I ask the first panelist to come and be seated? As they take the stage, I'm going to introduce the moderator, who will then introduce the panel members. Guy Michael. Been in the gaming business a long time, Mr. Michael. Started in New Jersey. You'll notice that we relied somewhat heavily on expertise from New Jersey and Pennsylvania for this forum. And we did that for a reason. Like Massachusetts, New Jersey is a full-time commission. That is unusual in most jurisdictions. So it really was important for us to understand the workflow and understand the responsibilities of a full-time commission. And Pennsylvania being one of the newest jurisdictions, as President Fahrenkopf just mentioned, we thought those lessons would be of great value to us also. So Mr. Michael is behind me, but I'm going to introduce him. He was the Deputy Director of the Division of Gaming Enforcement in New Jersey. He now practices law. His law firm specializes in gaming law, and he's spoken at panels all over the world. He is an expert in gaming, so he's going to moderate this first panel for us.
Thank you. Thank you. Thank you, Gail. Commissioner Cameron. Thank you for that kind applause. We hope that we are informative today, and we'll start out with this very informed panel. You could probably say that this is maybe square number 2. If square number 1 was the passage of the gaming legislation here in the Commonwealth, then square number 2 is its implementation. And that's what the stage we're in right now. And maybe a more colloquial way to say the implementation is to ask the question, well, what do we do now? And there probably are no more qualified people to answer that question than the people we're lucky enough to have on the panel with us today. To my immediate left, as you may have figured out by the sign in front of him, is Stephen Persky. Despite his boyish good looks as he sits here today, Mr. Persky, it's hard to believe, 35 years ago, was the principal author of the New Jersey Casino Control Act as an assemblyman in the New Jersey legislature, then became a state senator, was the chief of staff to Governor Florio, became the chairman of the New Jersey Casino Control Commission, and then a judge in the Superior Court of New Jersey. He's been around, and he knows this area like the back of his hand. I assume he knows the back of his hand, and should be able to answer all the questions that you have. Next to Mr. Persky is Kathy Walker. Kathy is also a former regulator. She was with the New Jersey Casino Control Commission for some 13 years, and then she left the government side and has gone over to the operational side. She was a high-ranking executive with the Trump Organization, with Harrah's, and with Players Hotel, and is now the president and chief executive officer of Seneca Gaming Corporation, a tribal casino in upstate New York. Finally, at the end of the table there, is Kevin O'Toole. Sometimes you can spot talent right away, and in 1981, a bespectacled younger man walked into our offices at the Division of Gaming Enforcement, and we hired him because you could tell that he had a great deal of talent. He worked for the Division of Gaming Enforcement then for many years, left, and then served as executive director for the Oneida Indian Nation Gaming Commission, ultimately becoming a commissioner there, and is now the executive director of the Pennsylvania Gaming Control Board. So those are our 3 experts on this panel, and I think you can tell from their backgrounds that they certainly are experts. I'd like to start with a question for whoever wants to chime in at probably the most basic level we possibly can. What is the role of a gaming commission? Steve, you want to start?
The role essentially, initially, starts with the mandate from the legislature, and I would indicate that my review of the Massachusetts legislation suggests that the governor and the people in the legislature in this state, in this Commonwealth, excuse me, took their responsibilities very seriously. A very significant range of important policy decisions were in fact articulated in the legislation. Even more significantly, the legislation gives to the commission and to the enforcement office the powers and responsibilities that they need to have, and the authority that they need to have, and the insulation from political and other influences that they also need to have. So that my answer to your question, Guy, first is that the regulators have been given a responsibility to advance the public interest as the legislature defines it in the context of this industry, with its past history, not more recent. The regulators here, as elsewhere, must always be sensitive to the concept that the public is watching, and the public has every reason and every right to watch, and the public has every reason and right to expect that the operations of the casinos will be conducted in strict compliance with every applicable law and regulation, and that the regulators have both the power and the will to make that so. The bottom line is that the public invests significant confidence in the regulatory process and in the regulators themselves, and that is both as it should be and dangerous, because it means, as with all appearance issues, If there is a problem, it's very difficult to unmake the mistake. And therefore, the regulators have to be mindful from jump of not only what their responsibilities are, but the need to attend to the fact that the public is watching.
Kathy, you have something to add? Could you also address maybe the relationship that the Commission would have with the industry itself, too?
Yes, thanks, Guy.
Yep.
I have a little different take on it than Steve had. I believe that the regulators need to provide a fair and efficient process that is standardized for all of the applicants so that there is consistency in the process, that there is fairness in the process, but also that there is a sense of decorum and respect, and that there is a high level of confidence in the regulatory process. And I think much of that can be done between regulations, and again, I keep saying process over and over. I believe that that is very, very important. I also believe that the regulators do have an advocacy responsibility. In looking through your statute, there are many public policy initiatives that are covered in there. And I believe that the regulators, not for one or two different operators, but for those public policy initiatives that are outlined there, that they have a responsibility to keep the legislature informed of how we're doing, benchmarking against those policies, and also to make suggestions of what might need to be changed or tweaked as you go forward in the process.
Okay. Kevin, some additional thoughts?
I agree with both Steve and Kathy, and I think that the role of the regulator is to ensure the integrity of both the regulatory process and of the casino operation. In my experiences, you always look to the legislative intent, and in Pennsylvania, they stated that the first and primary responsibility of the Gaming Commission is to protect the public through strict regulation of all aspects of gaming. So we take that as our mantra, and in all of the various policy decisions that we make, we try and evaluate what effect does that have on the gaming public, and does it further that purpose of having an honest and fair gaming operation.
You've all used the word, as Kathy pointed out, process over and over again in your answers. Can you elaborate a little bit on that? What do you think are the main aspects of a process that makes a gaming regulatory agency work well?
Well, the first one is, I think, the most obvious: transparency. The public is watching, and the industry, of course, itself is watching. There has to be a sense of confidence by everybody in the processes and the decision-making that is going on, and that means it's got to be open out front. And that's kind of a given. Sometimes it's a little harder in actual practice, but it's got to be a mental discipline that you err on the side of providing too much information rather than not enough. And Kathy's absolutely right when she observes that the eventual policymakers, the legislature, who vested the regulators with this authority, have to be fully informed at each step along the way as well. And there are a number of different ways that can and should be done by way of dialogue. The Commission, for example, could regularly invite the appropriate legislative committees to ask the Commission to come in and make a report to the legislature.
Kathy?
Yeah. In my mind, at the early stages, one of the most important things is to determine what your regulations are going to be so that everyone has written down how the process will work. I think that adds a lot, and I know one of the things that everybody says is, what did you learn? I think that in learning, when I worked in the New Jersey Casino Control Commission, is what we learned is that in every area where we didn't have a written regulation, somewhere along the line, it bit us.
Right.
So if anything, my recommendation would be to make sure that you've covered the regulations, understanding that nothing is perfect, and regulations are there, and you have a process to be able to change them. But early on, I think that also adds to the confidence that the public can have in the fact that you've got a full, open forum for consideration of not only the regulations, but then how those regulations get applied.
Kevin?
Transparency in Pennsylvania is certainly a very important topic. The legislature in Pennsylvania established gaming caucuses on both the House side and the Senate side. So we are called over and we appear at various hearings throughout the year to discuss the status of various matters involving the casino industry. So to a large extent, we answer to the legislature, and we're accountable to the legislature, and we're mindful of that. But certainly, to be truly transparent, you need to have a free flow of information and really good lines of communication. And I think one of the best ways to do that is through technology, without a doubt. It's very important that in today's environment, a Gaming Regulatory Commission establish a very robust website. We post so much information on our website; it's incredible, and it can be viewed as rather intrusive to some extent. But it's an effort to be transparent, to let all of the various constituencies and the general public know, number one, how we spend money. We post monthly all of the expense reimbursements of anyone in the Pennsylvania Gaming Control Board who has received an expense reimbursement. That same obligation applies to the Pennsylvania State Police, to the Department of Revenue, and to the Office of the Attorney General. We post every right-to-know request that we get, how we handled it, and what the disposition of that was. We post contracts that we've entered into, both contracts related to competitive bid processes or sole source bids or emergency requisitions. So that's one avenue that I think is very important in today's technological environment.
Guy, if I may, I'd like to follow up on a point that Kathy made, because it's really critically important to this commission. The legislature has vested the commission with, as I said, a great deal of power and responsibility. And indeed, in the sections where the commission's authority is defined, it, for example, says that the commission is to establish standards for debt equity ratio, a concept that in New Jersey we called financial stability. When I first got to the commission in 1990, after 14 years of operations by the commission, literally the first week I was there, I was told that one of our first responsibilities, or my first responsibilities with my colleagues, would be to determine the financial stability of one of our licensees, who at the time was tottering, as we say. I said, fine, that should be no problem. Let me see the regulations and the standards that define financial stability so that we can then set up a hearing and decide whether this licensee meets the standards. Well, we don't have any standards. We've never adopted regulations on financial stability. That made it very hard to conduct a hearing to determine whether that licensee was in fact financially stable. A second observation on the same lines, I note that the legislation gives the commission the authority to establish, or to permit rather, the licensees in Massachusetts to extend credit to gamblers or to patrons under certain circumstances. And that's neither unusual or surprising or particularly challenging. But again, it says to the regulators, you have the responsibility now to go look around, and there are, thankfully from your point of view, a number of places you can go to where there are extensive regulations on the subject of casino credit, which I suggest to you is terribly important in setting up a comprehensive regulatory process. My point simply is, as Kathy mentioned, the authority that you have has to be exercised with great detail in those areas that you're going to determine are significant for the operations of your licensees.
Let me get back a minute to the transparency issue that you've all raised too, and maybe getting into a little more sensitive area. Gaming commissions deal with all kinds of information, and are there not issues of privacy that need to be addressed as well, that whereas the public would not necessarily expect, although transparency is very important policy, that everything the commission does will be available to them? Are there some ways to protect against that kind of problem?
There always are, but you have to start, again, I go back to the legislation. It's the nature of the beast. Your legislation says that licensure, whether as a casino company or even as an employee, a key employee or whatever, licensure by the commission is a revocable privilege. It is not a right. That's an important concept to remember. The legislature put that in there to a purpose. And you're going to find that you're going to come back to that concept time and time again. In this particular context, it suggests, at least to me, that what in an ordinary course might be considered private information is, because of the need of the public for transparency, not going to be private. Now, Social Security numbers are easy. That probably always ought to be private. But there are a whole category of items that you would normally think of. I go to get a job, I shouldn't have to tell the world about my divorce, or I shouldn't have to tell the world about the lawsuits that I've been involved in, or the judgments that have been outstanding against me, or lawsuits that I was involved in, or whatever. And in fact, if you start with the notion that participation in this industry as a licensee for a casino company or as a licensed employee is a revocable privilege, that raises the standard somewhat on the determination of what should be public.
Anyone else have any thoughts on the public-private dichotomy?
I did, Guy. I think Guy has brought up what I think is one of the most difficult things that you as commissioners and your staff will wrestle with, especially when you get to the individual licensing, as Steve mentioned, you know, divorces, financial situations. There's always that balance. You obviously want to protect, to the extent you can, the personal interests and you know, respect that. But I do believe that all of us working in the gaming industry understand, and it would be important, in my view, for you to make sure that this is something that you get out right away, that you give up some of the right to the privacy that you may have as an ordinary citizen not involved in this industry. But I do think it's a difficult balance, and I think that commissions struggle with this each time a new question comes up.
Absolutely.
I don't mean for you to go last all the time, Kevin. I mean,
No, that's certainly all right. Certainly the balance between transparency and confidentiality is a difficult one. But the operators, when they submit a petition or a gaming floor plan change or a refinancing application, they will file with that a petition to maintain the substance in attachments as confidential. And in many cases, but not all, the Gaming Commission will approve the confidentiality and non-disclosure of that information. But another thing that we treat as confidential on a day in and day out basis is the casino's internal control submission. Now, there's certain aspects of that submission that may not be all that confidential. Certainly surveillance, security, how money flows within a casino, confidential and should never be disclosed. But we also have a compulsive and problem gambling plan. That is how the casino has advised us that they will handle that social issue. And it's part of the internal control submission, but it may not have, it may be something that would be instructive for the public to have access to or legislators to have access to. So if we get a right-to-know request for something like that, we have been asked and we have adopted a plan where we will go to the operators and request that they waive confidentiality and specify exactly what it is we're asking them to waive confidentiality on. And if they grant that waiver, we will send that information out.
Okay. Now, obviously, Massachusetts now is at the very earliest stages, and you've all been through situations where a gaming agency was at its very early stages. So, at a day one situation, what would you think would be some of the priorities that the Massachusetts experience here or other jurisdictions would have to address?
The range of day one, it's very difficult. I mean, you're starting obviously from scratch. One of the lessons that I believe the process in New Jersey could teach has to do with what I'll call community impact. Massachusetts is, as New Jersey did, focusing on the use of casino licenses to impact on the communities, economic impact, social impact, tourism, all of the public interest, if you will, impact. In New Jersey, at least from my perspective, retrospectively, the mistake that we made was to invest a sense of too much of that responsibility in the casino companies and not enough in the government agencies that start with the responsibility. By which I mean, at the beginning in New Jersey, it changed eventually. At the beginning, the concept was, as a part of your responsibilities as a gaming company in New Jersey, you will figure out ways to help the Atlantic City and New Jersey communities utilize the benefits of the investment capital that you're bringing. And it took about 10 years, in my opinion, for the government agencies to recognize that was not the best approach. The casino companies should be expected to come in here into Massachusetts and, having won the process of getting a license, should be expected to operate their facility, to comply with every commitment that they've made, to operate their facilities in full compliance with all of the requirements of the law and everything else. But they don't, as a company, necessarily have the expertise to determine how the resources that they are generating should best benefit the public interest. That, in my view, remains the responsibility of government, both at the state level and at the local and regional levels, so that it is indeed a cooperative effort. You can't do it without the involvement of the management of the casino companies, and you shouldn't think about doing so. But you cannot either vest all of the responsibility to determine how the public interest should be fulfilled. You can't assume that the casino companies can or should have that responsibility. My point simply is that the Commission has a role to play in this, but more significantly, so do the local governments and the state government, in order to define how the benefits of the investments by the casino companies can best benefit the public.
Kathy, you want to speak on that?
I just have, again, we've emphasized a lot the importance of the written process and the regulations. I think the other thing I would suggest that you want to be thinking about now, and I do know it's a longer process, is that down the road you have your licensees who are going to have 300,000 or 400,000 employees each, let's assume, plus you have your vendors who may have individuals that need to be licensed. So at this point, I would be putting thought into how am I going to work that individual personal license process, and how do I get that started early enough so that I can make sure that we don't get to a crunch point when a facility is ready to open and we haven't got the licensed individuals ready to go to work.
I think you said, I think you meant 3,000 or 4,000 each.
At each, oh, I'm sorry, yes.
You said 300,000 or 400,000.
300,000 or 400,000.
Oh, I'm sorry, 3,000 or 4,000
A lot of people woke up.
Sorry.
That's right. You got every unemployed person in Massachusetts already working. Yeah.
That would especially cause a crunch in the licensing
That
process.
surely would.
Okay.
Well, I certainly think that the commission, the Massachusetts Commission, is past day one, and it certainly seems like you're taking a very deliberative approach and studying what your next steps need to be. And in following up on Kathy's comment, you've got to you've got to look at technology, and I think Pennsylvania did an outstanding job very early on in determining how should technology be used to facilitate that process. Data is transmitted electronically today. It's stored and retrieved electronically. We developed through our IT professionals early on a system that we coined SlotsLink, and all of these thousands of applications come in electronically. There's a special computer link with every operating casino in their human resource department. So a new hiree or an applicant for a job at any casino can sit down at a dedicated terminal with the aid of an HR assistant, and they can complete their application online, and when they have all the fields filled out, press the send button, and we instantaneously receive that application. And then you have to also use technology to develop the workflow of that information. It has to be determined to be complete by your licensing intake unit. When it's determined to be complete, it can then be transmitted electronically to whatever agency or unit is going to conduct the background investigation. So, you know, you need to have technology that's going to look not only what they need to do in the next 12 months, but where you as an agency should be 3 years or 5 years down the road in the area of technology.
And you've all had experience in agencies and the structure of the agencies, establishing those structures. We'll start with Kevin this time so he doesn't feel so left out. What would you recommend in terms of any suggestions for internal structure of an agency, the kinds of units that are necessary and how they interact?
Well, that kind of dovetails to the potential question of how big should a commission get?
Well,
what
okay,
size should a commission be? And that's a continual challenge for the leaders of a gaming commission to, you know, try and make that evaluation. You know, or have you gotten to the point where you should be? In Pennsylvania, certainly there was the legislation there established a Bureau of Investigations and Enforcement, and they gave them the duties and responsibilities to conduct all background investigations. So it's a unit within the Pennsylvania Gaming Control Board. It's worked out well from my perspective. I've had 3 years to watch the operation of our BIE. We have hired experienced former law enforcement persons, former troopers from Delaware, New Jersey, Pennsylvania. We've hired former law enforcement agencies on a federal and a state level. So it's quality people, which would be akin to some very good companies out there that you could outsource background investigations to. They get the same personnel, these former qualified law enforcement personnel who know how to do background investigations. But we have been categorized as a single regulatory agency as opposed to a dual model.
Could you explain a little bit more what that means?
Well, it means that we have the investigatory and the adjudicatory roles both within the same agency. Now, if you do it that way, or if you're mandated to do it that way, as we were, you have to develop processes and procedures to ensure that the investigatory doesn't encroach the adjudicatory. And you do that, we do that through regulations controlling any ex parte communications, precluding any discussion on any outstanding matters from the investigatory side. BIE doesn't report to the commission. They report to the executive director for purposes of policy and administration. We have a bureau director and we have a chief enforcement counsel that work with our BIE. It opens, you know, it opens up certain questions. Is the ability to separate that effective? Is it working? And in my view, it is. But you're always going to, you know, face some critics that say you should completely separate the hierarchy between investigatory and adjudicatory.
I think that there are really 4 basic areas that you need to think about. Obviously, you have the employee side that has to be handled, and those individuals are your most important, the folks that you really need to take care of. You also then have the finance side, which we've talked about a little bit previously. You have the operations side, and then you have the company or the operator side. And I think that that would be at a minimum sort of the 4 different areas that I would see that you want to take a look at, lining up with, again, the public policies and then the mandate that you have from your legislature, and see whether you can fit each of those into those 4 categories. If not, you may need to create a 5th.
If the question of this entire process today and tomorrow, is something along the lines of what do we, as a new commission, really need to keep in mind and remember. The one common theme to all of this that I would ask that you keep in mind is the need to be light on your feet and to remain flexible. You're going to be going through processes with research, as you're doing today. You're going to get a whole lot of information on a given subject. You're going to then make a decision and implement that decision, and it will be, by definition, because of the integrity of the process, it will be a good decision, whether it's how to structure the agency, regulation on financial stability, whatever it is. It's going to be a good decision when you make it. And it's going to be a good decision for as long thereafter as the circumstances continue basically the same. And your responsibility on a continuing basis is to examine those circumstances and make sure that the good decision that you made at the beginning is still a good decision, because frequently, either by reason of technology or market changes or whatever, you're going to need to revisit some of those good decisions. In the context of the structure of the agency, the New Jersey experience is again, helpful in that respect. The people who started the agency in New Jersey in 1970, well, the legislation was 77, the agency created in 77, started work in 78, and they developed a model for the structure of the Casino Control Commission. And as Guy has indicated, in New Jersey, as you have here, the investigative and enforcement side was a different agency from the regulatory and licensure side. So we're talking about the commission as a regulatory and licensing agency. And a structure was developed with a table of organization, and as Kathy has indicated, eventually her 4 divisions is what it eventually wound up with, but at the beginning it was 6 or 7. In any event, by the time I got there in 1990, that structure had never been changed from its original concept. It was up at that point to 503 authorized positions, a number that shouldn't mean anything to you at all, whether that's large or small, except to tell you that over the course of the next year, we reduced that 503 to 360, a 30% reduction in the size of the commission, and not only didn't sacrifice anything, got more work done faster and cheaper. The point I'm making simply is that the good decisions that were made at the beginning about what size of a commission, how that commission should be organized and structured, worked well at the beginning, and then needed, and didn't get for a 14-year period, needed revisiting to make sure that the initial decisions were still the right ones. That's going to apply not only to how you build a casino control commission, it's going to apply to how you define financial stability. It's going to apply to how you impose licensing standards. It's going to how you evaluate internal controls. All of these kinds of questions are questions that will require your ongoing and continuous willingness to sit back and say, okay, that was right 2 years ago. Is it still right today?
If I can make a substantive statement, I would certainly second that. Flexibility is very important, and it ties into Kathy's point about, and Kevin also, about the initial stages and the bulk of work that needs to be done at the very outset that will probably be larger than the work that may need to be done as time goes on. And so to staff up on the basis of what you need to do right away may not be the best outlook to take, because that will only last for a temporary period of time. Also, to try to tie in a couple of things, there's basically, I would think, 2 type models of regulation. We talked about promulgation of regulations. Some jurisdictions promulgate very detailed regulations, and every casino has to follow every one of those regulations precisely. Some jurisdictions promulgate generalized regulations and say, well, fit within these minimum standards and then everything will be okay. Do you, in terms of advising the Massachusetts experience here on either one of those models, do you have thoughts on a preference or what you think might work better?
Well, we had pretty unique circumstances in Pennsylvania that I think kind of contributed largely to the fact that the operators in Pennsylvania have been successful. And that is we didn't necessarily have a grand plan in 2004, 2005, that the economy was going to take a significant downturn. But by authorizing initially slots-only gaming, casinos were able to build with a fairly modest capital investment, nice facilities that were convenient to patrons in fairly large metropolitan areas. And it got these casino operators off on a very good footing. And we only needed to promulgate regulations that covered the slot operations. But that, you know, that's still pretty extensive, covers surveillance and security, and we had very significant concern over underage gambling. It's certainly been an issue that we continually approach, and the casinos have done a terrific job to try and guard against underage gambling. The casinos wanted to get table games. The legislature agreed with that proposal, and we were able to implement table games subsequent to these casinos operating slots. So we were able to open up 9 operating casinos with extensive table game operations in the middle of 2010, and that necessitated us to promulgate additional table game regulations. And we had a unique set of circumstances. We wanted to make sure as a new jurisdiction, we expected many of these casinos were going to have anywhere from 80 to 85% brand new first-time dealers. And that can be kind of scary, and I'm sure Kathy would concur in that. Because it's a difficult job, very difficult job, and they hold the assets of the companies right in front of them in their chip tray.
They sure do.
You know, so we wanted to keep it simple. So it's what you might not understand is there are an enormous number of ways to play just blackjack. It's not, you know, it's not just one way and everybody does it that way. There are companies out there that that have these intellectual property scientists developing new wrinkles to every game. And now there's anywhere from 7, 8, 9, 10 different side wagers that you can place on the game of blackjack. There's traditional blackjack and then all these little variations. So we wanted to go and keep it simple early, and we just promulgated regulations that allowed the casinos to play and operate the basic games. We allowed some progressive wagers in there, and we said, look, come back to us in 3 months, 6 months, and we'll be flexible, and we'll give you some of these side wagers or most of the side wagers. And that's kind of how our regulations evolved. The side wagers are not particularly favorable to the player. They're more favorable to the house. But most people understand if I put a dollar wager over here, it's like buying a lottery ticket. The chances aren't that great that I'm going to win the major jackpot for that dollar. But when I make my wager at the traditional game of blackjack, I want to make sure that it's being played in that traditional fashion where there is a house advantage, but if a player plays smart, plays intelligently, they have an opportunity to go away a winner.
I think some of it depends on the subject matter, and Kevin touched on it. In areas such as surveillance, credit, some of the areas that are the high integrity touch, responsible gaming, I think you need to be more specific so that there are clear guidelines. But in other areas, between technology and the changes that are coming on, you may want to consider building in more flexibility right at the beginning, because one of the things that frustrates operators the most is that a new piece of technology has come out and regulations were developed, and those regulations were developed based upon what vendor X did a year ago, and now vendor Y comes in and vendor Y has a better way to do things, but it doesn't, or a different way that doesn't fit within your regulations. So then there's that time period that it takes to get the regulation changed. So I think it's more on a case-by-case subject matter basis.
And that's essentially exactly what I was going to say. It depends. Some things you need to be incredibly detailed. Some things you need to set minimum standards that satisfy the public interest, and let the operator work from there.
If I can just supplement that slightly, because the Native Americans, through the National Indian Gaming Commission, had a very effective way of dealing with technology. I had the pleasure of serving on a tribal advisory committee during my period with the Oneida Indian Nation, and they set out to develop minimum internal control standards covering every Native American tribe in the country. So you can just imagine the scope of trying to get one set of regulations that have relevance at any type of property. But as we went through topic by topic in the regulations, we always ended that topic with a provision that said, if a casino licensee finds a way to use technology to improve the process described above, they can submit that to the Tribal Gaming Commission for approval, and it would comply with this section. So I thought that was, unfortunately, the National Indian Gaming Commission lost the court case, and they don't mandate those minimum internal control standards on Class 3 casinos. But that's one way of being flexible to the operator to allow them to submit procedures that might be different and use technology in an effective way.
Let's talk a little bit more about the increase in and the expansion of gaming technology. When we all started, you know, a slot machine was basically a handle.
In the year one, yeah.
Yeah, right. A handle and some pictures of fruit on it. But now, obviously, it has changed drastically.
It's a computer.
It is a computer, and then how about, you know, internet and online and all of those kinds of things? What suggestions would you have for, again, flexibility, I suppose, is the key, but are there any other more specific kinds of recommendations that you would give in terms of handling the new technology?
Only that the focus has to be by the regulator, in this case the Massachusetts Commission, on identifying the interest that needs to be protected. And in the case, obviously, of technology, you want to be sure that as the regulators you understand what the technology is and that it meets the public interest in terms of fairness of odds or whatever it is. The technologies are going to evolve faster than whatever the pace has been over the last 10 years, it's going to increase over the next 10 years. So being light on your feet as regulators becomes even more important in that respect. Keeping up with the technology is difficult in that sense, but not if you keep your eye on the target. The target is, does this new development pose any risk at all to what we have defined as the public interest? And if it doesn't, let it be. And if it does, try to figure out a way to get the proponent to meet the standard that you're talking about. As far as the internet is concerned, that raises, at least to me, very significant issues that probably can be resolved but need to be addressed very carefully in terms of the integrity of the process, in terms of knowing who's doing the gambling, in terms of making sure that the games are consistent with the standards that you're setting here. I think that as technology evolves, it will be futile to say that we cannot affect a valid regulatory process over internet gaming. I think that that's going to be a Model T Ford at some point. I think the regulatory process has to get to the point where it can trust that system, and it will be the responsibility of the proponents to devise that system and that meets the regulatory standards, and it will be the responsibility of the regulators to understand what their interests are and to undertake the appropriate evaluation.
We've been all so calm and agreeable so far. Let me see if I can get a little bit of a fight started or something here. Kathy, you're an operator now, and Kevin, you're a regulator. From your different perspectives as an operator and as a regulator, what would you like to see? How would you like to see an agency deal with internet and new regulation, new technology?
Well, I think one of the things that President Fahrenkopf touched upon, and the thing that I would like to see is for everybody, when new technology comes out, I'm like everybody else. I don't understand it. I don't know what this is. First, I would say, get yourself a 22-year-old who you trust and understands IT security, somehow involved with your commission. I think that that's very, very important because there is so much sophisticated change in technology that you need an expert. And some of us that are a little older here have to understand we have to rely on those individuals who know this area. I think the other piece of it is that you've got to remember that technology also brings in more accountability. And what you find is that somebody comes in with some new whiz-bang thing, but it also has a back-end system associated with it that will give you better control over the revenues, the play, and more information that's there. So I would suggest that this is one of the areas where you want to keep maximum flexibility because it changes on a daily or weekly basis in this industry.
There's a couple of points there, obviously, but on the internet and online gaming, we certainly view that as requiring legislative action in Pennsylvania. But certainly as a regulator, I would be hopeful that if coordination between the federal government and the state governments over online and internet gambling works out and moves forward, that the legalized casino industry have a significant role in being able to use that technology to their benefit. And the other point in terms of technology is I had read about this before I came to Pennsylvania in 2009, and since I've been there, it still amazes me that we have a central control computer system that is linked to every single slot machine in the Commonwealth of Pennsylvania. We know when $1 of revenue is earned by Kathy's Casino, if she was in Pennsylvania, at exactly the same time that Kathy knows when that dollar is earned. And this computer system calculates the tax liability from that revenue without any intervention from my agents or the commission. And
is that how it used to be?
It's really fascinating. It's technology at its best. There are companies out there that have the ability to set that system up. These are companies that have set up equally sophisticated lottery systems throughout the world. And in Pennsylvania, it's overseen by the Department of Revenue, which I'm also glad about too, as opposed to the Gaming Control Board. But it's not that way on the table game side. So you do have to have systems in place to ensure the proper collection and counting and recording of revenue on the table game side in a more manual environment.
Under the heading of maybe starting a fight, let me ask a question. And this is a rhetorical question for the commission. I don't want anybody on the commission to feel that they need to respond verbally or by body language in any way. But Stephen Persky wants to be licensed as a key employee in one of the companies that has a license in Massachusetts and comes in and says, here's my licensure in New Jersey, here's my licensure in Pennsylvania, that's all you need to know. Is that going to suffice to have you, as the people charged with the responsibility to the people of the Commonwealth of Massachusetts, say, okay, that's good enough? Phrased in a more general way, what should be the future of interstate or inter-agency processes and standards with respect to licensing either of individuals or of product? Does Kevin, running the Pennsylvania operation, believe that his commission can simply accept at face value what the determinations of another jurisdiction have been, even if that jurisdiction is one, for example, that he helped to create? Kathy, on the other hand, as an operator, would like to believe that if she can establish her licensure and qualification to an agency that has sufficient authority, that ought to be good enough for everybody else. This is a concept that, as new regulators, you're going to be facing and dealing with. You just heard Frank Fahrenkopf mention that the AGA is looking to try to encourage this on a national level, and it's going to be an issue that every agency is going to have to face.
Speaking of new technology, as Gail had pointed out, we have questions coming in from the ether somewhere that I can now try to pose to you as we wind down. One of them is, and Frank Fahrenkopf touched extensively on this, what programs in your various jurisdictions that you've been involved in have been implemented to address problem gambling?
Well, we wanted to address that issue head-on, and we gave it the status of a director-level employee at our agency. I think we may have been one of the first agencies to have a director oversee our Office of Compulsive and Problem Gambling. And then we established the requirement that the casinos provide a compulsive and problem gambling plan. They lay out in detail training programs, mandatory training programs that they pretty much apply to their entire work staff for what should they do if they see a person who they feel is gambled too much or is talking verbally in a despondent way about gambling, and it works. That has been effective. We also, from a regulator's standpoint, we've had a self-exclusion list, and we're up to about 3,500 people in the last 5.5 years have placed themselves on the self-exclusion list. The policy determinations in that, if you decide to have one, and most jurisdictions nowadays do, is what terms should there be? And we have a 1-year, a 5-year, and a lifetime ban. One jurisdiction, I think it was Missouri, perhaps, had only lifetime bans, and they got up to 12,000, 13,000 lifetime bans, and they figured they should have some procedure to allow a person after a certain period of time to request to come off of the self-exclusion list. Social scientists in the area of compulsive and problem gambling have done studies on self-exclusion lists, and they have found them to be effective. And some social scientists say that a person can be a recovering compulsive gambler and still be able to manage some degree of gambling after a period of recovery. I'm not a social scientist. I'm not offering any opinions in any of those areas, but it is a very important issue. Funding is also a crucial component of the issue of compulsive and problem gambling. And as much as I admire New Jersey, I think we all kind of look at that model as the gold standard. They never got that funding issue right. Their provision in New Jersey was when the Council on Compulsive Gambling in New Jersey had trouble doing a lot of projects, the legislature came forward and said, okay, here's what we're going to do. We're going to give you the first $600,000 that the Division of Gaming Enforcement prosecutes and the Casino Control Commission issues fines. So they pegged funding with fines. There's a bit of irony there because as a regulator, you want your industry to comply 100% of the time. You know that that's a standard that most of them aren't going to be able to meet, but that's the goal, and that's what you want to impress upon them. But compulsive and problem gambling wasn't going to be funded if the casinos didn't occasionally screw up and the Enforcement Council didn't bring actions.
Can I ask a question about this?
Sure.
From everything I can tell, there is a lot of serious attention paid to the compulsive gambling issue.
And underage.
Yeah. To understand the extent to which pursuing this issue is counter to the industry's interests, do you know more or less what percentage of revenues comes from compulsive and problem gamblers? To what extent is that cohort significant to the success of the industry?
I haven't ever seen any data specifically on that, although as you've seen and heard today, and it's been a consistent conclusion for a long time, that that the percentage of the population that suffers from this is very small. But I have never seen any data that translates that into revenues. I would suggest, and this is an important concept I hope that you will keep in mind, Kevin is right, at least in my view, when he criticizes the linkage the New Jersey legislature made between funding the program and the assessment of fines. And I don't think that was particularly smart. But the fact is that although every company, I would assume, would tell you and mean it, that they would much prefer that no underage gambler and nobody on the self-exclusion list or on the exclusion list would ever be marketed to or promoted to come to the property, that mistakes get made. And somebody's not watching while a kid who's 18 or 19 years old, when it looks like he's 23, is playing a slot machine, or that somebody who's got a computer list to send out to invite people to a weekend sends it to somebody who's on the exclusion list. Mistakes will get made. I would, forgetting for the minute about linking fines with anything else, I would suggest to you that even though they are mistakes, that the commission should have a very strict policy in dealing with that. Certainly if it's intentional, that's a whole nother category, but even if it's a mistake, a significant and very visible sanctioning system should be in place and consistently and immediately utilized so that the message is very clear. That as regulators we cannot tolerate, and we want the industry to help us not be able to tolerate violations in these areas. That's a terribly important message that the regulators need to convey.
Do you know anything, Kathy, about where the money comes from?
Yeah, I don't know of any studies that have done that. You know, it's one of those issues where it's difficult to get information. Obviously, if somebody comes in and self-excludes, right, then you can always go back and say, well, let's look at what that person played. But you have those individuals who don't go through that process that are in the mix as well. I think that again, one thing that Pennsylvania has done very, very well, and I think it's something for you to consider, is to make sure that your licensees are all linked on these self-exclusions. I think that's a very, very important piece of this, because if you self-exclude at Casino X, you need to make sure that they're excluded within the jurisdiction, because the goal here is to help an individual that has a problem. The last thing you need them doing is, you know, the next day waking up and going from one to another.
Here's an instance, by the way, where the advancement of technology can help by cutting down on the mistakes.
Yep.
My experience, too, has been that the industry, certainly in the last decade, has become very sensitive to this issue. And as a casino industry, there are enough public relations problems that casinos can have. They don't need this headache as well. And it's simply not good business for word to get around that people have been taken for more than they should have been. And that, you know, the casinos are very active. Harrah's, I know, has done enormous work in terms of developing.
Harrah's was the leader many, many years ago.
Right. Project 21, I think
Right.
they called it,
That's
about
right.
underage gambling. And there is a great sensitivity in the industry to this kind of problem and to avoid it. Pennsylvania has, don't they have staff that are devoted exclusively or primarily to problem gambling?
Well, what we have done, we have a director and a program coordinator, but we've trained all of our on-site personnel to be intake persons for self-exclusion lists. So if a person is at a casino and while they're at the casino, they get the epiphany that I got to stop this activity, they can put themselves on the list by meeting with one of our agents at the casino.
We're getting near the end. There's another, we won't be able to cover all of the questions that have come in. Some of them are maybe more appropriate for other panels, and I'll hand them to those moderators, and maybe they can get to them as well. But here's one that we can address. Did cities receive, it would be in Atlantic City in our case, did cities receive money to cover increased safety and traffic costs, infrastructure costs?
Yes and no. I mean, that covers the ground, I guess. In Atlantic City, there was no direct payment, either by the state or by the industry, to the city. But certainly the city's ability, financial ability to do what it needed to do was dramatically impacted by the development of the casino industry. Again, just giving you historical figures, in 1976, and again, the numbers are ancient, but in 1976, the total assessed value of all real estate in Atlantic City was $297 million, call it $300 million. Over, let's say, the next 15 years, as of when the Taj was built in 1990, there was some $6 billion of investment put into the city. Obviously, that had a rather dramatic effect on the city's tax base, and of course, in addition to shifting, I don't even remember what the percentages are anymore, but in addition to shifting 90-some% of the burden from the homeowner to the commercial side, it provided the city with all of the resources that it needed to be able to do what it needed to do.
Just one comment on that is that of all the jurisdictions I've worked in, New Jersey was the only that didn't have a local host community share portion to help cover some of those expenses.
We do have a local share assessment. It's 4% of the 55% tax rate on slot operations and 2% on the 14% tax rate on table games.
Yeah, and I do know that the Massachusetts statute deals very directly with the host community impacts and surrounding community impacts on a very
it does indeed, in a very comprehensive way.
I think we've bumped up against the time limit, so I want to thank the panel for wonderful discussions and thank you for your attention.